Greetings, Jason the Apple Watson here. I'm about to lead you through the complex journey of family court, offering insights and practical advice, especially for those just starting out. I'll outline the starters between snakes, solicitors, I call them, and Mackenzie friends in this realm. You might wonder why you should spend your value with me, especially under such stress. What could possibly be gleaned from an appearance that's more Scooby-Doo, Shaggy, or Liam Gallagher in person? You see, navigating the court system in England and Wales can be an overwhelming experience, especially when child arrangements are at stake. Let me give you some compelling reasons to listen closely to my take on family court and family law. I've been a pillar of support for families, predominantly fathers, steering them through the murky waters of family court. My journey has deeply changed me, a testament to the profound impact this work can have on a person. With a recommendation rate that hovers around 96% from those I've assisted, I'm confident this video will provide more information. It will offer valuable guidance, albeit family law is hardly the topic that screams entertainment. It's crucial, yet charged because it involves our children, leaving us like a part of us is unjustly taken away. My mission is yet necessary. I intend to transform family courts into spaces where resolution and healing are not just lofty ideals, but tangible outcomes. This drive stems from my personal battles, significantly shaped by the challenges of combating narcissistic tendencies, a gift or a curse continuously bestowed upon me by my ex-wife. Among you need to navigate the complexities of dealing with ex-partners exhibiting similar traits. Despite this journey's stagnancy over the last decade, with the same wary narratives and deceptive tactics prevailing, I see a glimmer of hope for change, for a future where children desire time with their biological fathers without any bias. Your time, like mine, is priceless. The goal is to offer wisdom derived from my own missteps in family court, the wrong advices that left me vulnerable, and my relentless critique aimed at refining the system. I do not align with the extremes. My sole focus is focusing on and fostering a system that prioritizes fairness and child well-being above all else. Although my perspectives have often been misunderstood or dismissed, especially in the professional circles, I stand firm in my convictions, driven by personal history that has, decisively soared up the prospect of the future relationships for me. My journey through the minefield of courts decisions, my daughter, has been arduous yet enlightening, ultimately strengthening our bond. Propose may at times seem unrealistic, but with every suggestion it's made with the child's best interest at heart, aiming to mitigate conflict. And it took me a lengthy period filled with anger and blame to realize that change begins with me. Often men feel isolated and misrepresented in family courts, a sentiment stemming from lack of proper education and understanding of the processes involved. Today, I will delve into the recent changes in Cafcass policies and procedures implemented on October 9th, 2024. Understanding these policies is crucial for holding professionals accountable and ensuring they are followed to the letter, while acknowledging the presence of integrity within Cafcass and law enforcement. It is also my responsibility to identify and address any malpractice. I've always considered the immense power of these entities. They have so much power, it's ridiculous, so they need to be held accountable. Here's how you can make sense of the complex and emotionally charged process. First, you must understand the legal framework. And by that I mean the Children Act 99 is central here. This act puts the welfare of the child at the foremost priority in any decision made by the court. Every decision rests on what's called the paramountcy principle, which means the child's needs and welfare are the top priority. Now, the courts use something known as the welfare checklist to evaluate these needs, and they look at everything from the child's physical, emotional, and educational needs to the potential impact of any changes in their situation. This also subscribes to the no order principle. Essentially, the court won't intervene unless it's necessary. The principle of parental responsibility is another cornerstone. This details the rights and duties of parents concerning their child's upbringing. Next are the additional pieces of legislation you'll need to grasp. Family Law Act 1996, for example, is crucial for protection against domestic violence, while the Children and Families Act 2014 introduced reforms pertaining to child's welfare, adoption, and justice systems. International conventions also play a role. The Hague Convention on International Child Abduction 1980 is vital for cross-border disputes, while the United Nations Convention on the Rights of the Child influences the interpretation of the children's rights in the domestic sphere. Case law is another layer. Decisions from higher courts shape how courts are practically applied, offering precedent that your case might follow. Guidelines and regulations further granularity. These cover a range of circumstances from adoption procedures to foster care. The implementation of these laws aligns with their intended purpose. Understanding this framework gives you a clearer picture of how decisions are made in the best interests of the child, whether you're negotiating directly or presenting your case in court. Now, let's look about self-representation. There's a significant advantage here if done correctly. For starters, it can save you money on legal fees. It can be prohibitively expensive with solicitors. It also grants you direct control over your case, ensuring that no middleman distorts your intentions or concerns. There's a deep personal satisfaction of an empowerment that comes with representing yourself, and it can come with a level of flexibility in managing your case. That's simply not possible when reliant on a schedule. Ultimately, knowing the particulars of your case allows you to communicate directly and clearly with other parties, possibly leading to more straightforward negotiations. Nonetheless, the self-representation isn't without its challenges. Common pitfalls include a lack of detailed legal knowledge, which can lead to strategic mistakes. Procedural missteps might delay and even harm your case. Handling evidence properly is vital and something not everyone is adept to. Emotional objectivity is difficult. Family matters are charged and decisions can be clouded by emotion rather than strategy. Settlement opportunities might be missed without a firm grasp of legal nuance. Effective advocacy requires skill and experience. Without it, conveying your position clearly can be tough. And courtroom etiquette and presentation influence. Outcomes. Familiarity with these can make a poor case. Misinterpretation of the law can also lead to adverse decisions. Cross-examination, both conducting it and being cross-examined, requires acumen not everyone possesses, and you can't follow the same steps when you're cross-examining as a litigant. Negotiation skills, especially in high-stakes settings like child custody or property division, are crucial. Therefore, while self-representation can be beneficial, it demands thorough preparation and understanding of the landscape that you're navigating. Wherever possible, you need to seek advice from a trained professional like myself to bolster your efforts. Thorough preparation, careful planning, and deep knowledge of the legal framework are fundamental to your success. Navigate the family court process. In doing so, you're ensuring that your every decision aligns with your best interests and the best interests of your child, which is the ultimate goal. Now, I want to gather to discuss an important turnaround in our practices, a topic that is crucial as it is complex. Cafcass's new domestic abuse practice policy. This policy launched just recently on the 9th of October. It's a substantial step forward in safeguarding child and adult victims of domestic abuse. It is my aim to educate and arm you with the knowledge and clarity necessary to enact these changes effectively in your daily work with families, courts, and most importantly, children, your family. Let's start with the core of this policy. It mandates that family court advisors, the FCAs, and children's guardians must ensure that the voices and experiences of children and adults who have endured domestic abuse are accurately and respectfully represented. There is a significant shift in language. They no longer use terms such as claims or alleges. These words frankly minimize and diminish the lived experiences of the abuse survivors. Instead, they must faithfully, with their words, he said, she told me. This change is right and necessary because it honours the reality of the trauma establishes crucial baselines of respect and validation. One of the most pivotal aspects here is the establishment of a starting point for cases involving a parent under investigation or convicted of sexual offences or violent crimes. The recommendation is no contact with the child. This is a non-negotiable unless there is a compelling rationale otherwise, which must be documented comprehensively. This rule aligns with the Domestic Abuse Act of 2021. It follows Practice Direction 12J and 12Q to ensure that we are not only legally compliant, but morally aligned with the highest standards of child safety and respect for victims. The policy insists on a clear and articulate explanation for any deviation. This is not discretionary, but mandatory practice. Any recommendation for a child to spend time with such parent, backed by robust evidence and reasoning, shared with both the court and the managerial chain of command, is not just a bureaucratic hurdle. It is a safeguard to ensure that every decision is made with the utmost consideration of the child's immediate and long-term welfare. Further, this policy explicitly integrates updated child-centered measures. Cafcass have been tasked with an unyielding responsibility. Prison judge can lead to grievous consequences. Therefore, continuous reflection on practice and learning is essential. This policy mandates the use of specialised domestic abuse training and practice guidance to sharpen the skills of assessment skills, particularly in identifying and understanding coercive and controlling behaviours. Special attention must be paid for the cultural context of families that the Cafcass officers engage with. Cultural beliefs and practices can significantly influence a family's dynamic and their responses to abuse. And it's crucial that the Cafcass officers seek to understand these nuances. They evaluate them thoughtfully and integrate the understanding that their analysis and recommendations. For those cases where fact findings are in process, any interim contact with the accused must be critically assessed for Safety Practice Direction 12J. Provides a framework for which Cafcass operates diligently, ensuring that the child's safety and well-being remain paramount. Never recommend parental supervision of contact by an abusive parent under any circumstances, even if the parent offers to do so. A child's reluctance to see parent, often labelled parental alienation, must be scrutinised with a lens of potential domestic abuse and harmful parenting. The harm caused by such behaviours, often deep-seated and long-lasting, time with an abusive parent should only be recommended if there is unequivocal evidence of sustained change and no further risk of harm. In situations where a parent and child are living in a refuge due to domestic abuse, contact arrangements with the abusive parent are inherently unsafe. This policy mandates such arrangements to be suspended and urgently reassessed to ensure ongoing safety for these families. Lastly, and important to respect the process victims go through to come forward. Disclosure of any abuse can be painstakingly slow, often due to fear of trauma. The role of Cafcass officers, patience, empathy, and an environment that feels safe enough for victims to tell their truth. These policies and practices are not mere formalities. They are lifelines for the vulnerable in society. Adherence to these guidelines should be monitored thoroughly, with serious consequences for non-compliance, including referrals to social work or even judicial review. I expect Cafcass' commitment to these principles can be profoundly impact the lives of the children and families. If they don't endeavour to execute these directives with the gravity they deserve, ensuring that every child and every victim receives the protection and respect of justices they are entitled. That's including men, because I feel that this is stigmatised against men, to be honest. The policy emphasising accurate recording of victims' statements and prioritising child safety aims to mitigate misunderstandings and potential biases. However, one of the pitfalls could be its implementation, particularly if allegations are false. Potential pitfalls include risk of bias. There is an inherent risk of bias if the system is too quickly assumes the guilt of the accused based on allegations before the investigation, which could lead to unfairly restricting the parent's access to their child. Due process concerns. Ensuring that the accused has a fair chance to present their side is crucial. Any failure to do so can compromise the principles of justice and due process. Emotional impact on children. If allegations turn out to be false, the children may be unnecessarily deprived from a relationship with their bond based off those allegations, affecting emotional and psychological harm on the child. Reputational damage. Even if allegations are later proven false, the accused may suffer irreversible reputational damage and personal and professional consequences. Resource allocation. False allegations can divert resources away from genuine victims in support, potentially undermining the system's effectiveness and credibility. Emphasis on thorough recording and managerial oversights aims to balance these concerns, but its effectiveness would largely depend on the meticulous, unbiased implementation and continuous review of safeguarding to safeguard against such pitfalls. And that, I don't think they will do very well at all. In fact, if you get a Cafcass officer that's putting you and doesn't give you the opportunity to get out of that box through constant gaslighting and make you be someone that you're not, that report can ruin you, and the courts will listen to it. How you treat Cafcass and how they treat you matters. For further help, don't be shy in giving us a call. Peace and Lighter's Glove.